Welcome once again to our continuing reading of a treatise on the law of tort. My name being Christopher Neufeld of Neufeld Legal. And in this chapter, it will be chapter 3, Personal Disabilities. There are certain persons who cannot sue, whilst there are others who cannot be sued in tort owing to personal disability. Who cannot sue? 1. A convict, whose sentence is in force and unexpired, and who is not lawfully at large under any license, cannot sue for the recovery of any property, debt, or damage whatsoever. 2. An alien enemy cannot sue in his own right. 3. A wife cannot sue a husband for tort, nor a husband his wife. As to torts committed against the wife by her husband, the wife may sue her husband for the protection and security of her own separate property. But further than that, no husband or wife shall be entitled to sue the other in tort. Divorce does not enable the divorced wife to sue her husband for a personal tort committed during coverture, citing Phillips v. Barnett. 4. A corporation cannot sue for a tort merely affecting its reputation, citing Mayor of Manchester v. Williams. Personal injuries in the sense of bodily harm or offense cannot be inflicted upon corporations. It can sue for a libel affecting property, but not for a libel purporting to charge the corporation as a whole with corruption. The individual officers or members of the corporation whose action is reflected upon are the only proper plaintiffs in such a case, citing Mayor of Manchester v. Williams. 5. A child cannot maintain an action for injury sustained while en ventre sa mère, citing Walker v. GNR Co. 6. A bankrupt cannot sue for any direct tort to his property, the cause of action for any injury whereby the estate divisible among the creditors is directly diminished belongs to the trustee, citing Hodgson v. Sidney. But for injuries of a personal character, such as libel or assault, or the seduction of his servant, a bankrupt may sue. In some cases, the act complained of may be such as to give rise to both classes of damage, both a damage to property and also a damage of a personal character. And in such cases, the question as to what extent the cause of action will pass to the trustee seems to depend upon the following rules. A. If only one of the two classes of damage suffered is a direct consequence of the defendant's act, and the other is consequential merely, so that there is but one cause of action, then if the damage which is directly suffered is a damage to property, the cause of action passes to the trustee, and the bankrupt's remedy in respect of the injury to himself is gone. But if the damage which is directly suffered is of a personal character, the whole cause of action remains in the bankrupt. B. If the action of the defendant be such as to give rise simultaneously to two distinct causes of action, one in respect of a damage to property, the other in respect of a personal damage, as for instance where a carriage which the bankrupt is driving is run into, and both carriage and driver are injured, citing Brunsden v. Humphrey, the trustee may sue for the one and the bankrupt for the other. C. Intermediate between the two above classes of cases is that of a trespass to land or goods of which the bankrupt has the bare possession, and the trustee has the property, in which case it appears that the bankrupt may sue for the invasion of his possession, and recover damages, nominal or substantial, according as the trespass was or was not accompanied with matter of aggravation, and the trustee may sue in respect of his property or right of possession, and recover damages for any injury done to the land or any damage to or conversion of the goods, citing Clerk. Who cannot be sued? 1. Sovereign. 2. Foreign sovereigns. 3. Ambassadors of foreign powers. 4. Persons who for extreme youth or unsoundness of mind are mentally incapable of contriving fraud or malice. Infant. 1. An infant is liable for the consequences of a wrong which have been induced by and have arisen out of a contract, but which is independent of the contract in the sense of not being an act of the kind contemplated by it. He may be sued for a tort, but not when it would have the effect of making him liable on a contract which he could not otherwise be liable upon. Citing Damol v. Ram Chodar. If an infant assert that he is of age, and another act upon it, the infant is bound, whether such assertion is of his knowledge true or not, citing Wright v. Snow. But if the other party know that he is an infant, and so is not deceived, the infant is not bound, citing Nelson v. Stalker. A plea of infancy constitutes no defense to an action for assault, false imprisonment, libel, slander, citing Hodgman v. Grisel, DeFries v. Davies, seduction, trespass, citing Bacon, wrongfully detaining goods, citing Mills v. Graham, and embezzling money, citing Bristow v. Eastman. An infant may be restrained from selling spurious articles, represented by him to have been manufactured by the plaintiff, citing Chubb v. Griffiths. An infant in the actual occupation of land is responsible for nuisances and injuries to his neighbor, arising from the negligent use and management of the property. But infancy is an answer to an action for deceit, and to actions of tort founded on contract. Where the defendant who was an infant hired a mare for riding and injured it by overriding, the defendant's infancy was held to be a good defense, citing Jennings v. Randall. But where the defendant was expressly told that the mare was unfit for leaping, and the mare was put at a fence, and attempting to take it fell upon a stake and was injured and died, it was held that the infant had committed an actual wrong, and was therefore liable irrespective of the contract, citing Bernard v. Haggis. 2. An infant cannot take advantage of his own fraud. For example, he may be compelled to specific restitution, where that is possible, of anything he has obtained by deceit, nor can he hold other persons liable for acts done on the faith of his false statements, which would have been duly done if the statement had been true. Where an infant had obtained a lease to a furnished house by representing himself as a responsible person and of age, the lease was declared void, and the lessor to be entitled to delivery of possession, and to an injunction to restrain the lessee from dealing with the furniture and effects, but not to damages for use in occupation, citing Fairhurst v. Liverpool Adelphi Loan Association. An infant is not responsible for falsely affirming goods to be his own goods, in that he had a perfect right to sell them, and thereby inducing the plaintiff to purchase them, citing Gross v. Neville. But if such actions were maintainable, all the pleas of infancy would be taken away, as such affirmations are in every contract. A. An infant borrowed money from B on a mortgage of certain immovable property. B, believing that A was of age, advanced the money. When B brought his suit on the mortgage, A pleaded infancy, but the plaintiff based his claim on the fraudulent representations of A as to his age. It was held that where an infant was not liable on his contract, the plaintiff could not succeed against him by framing his action in tort, and that what the plaintiff could not recover ex contractu, he cannot be permitted to recover by simply changing the form of his suit, that is, by framing it ex delicto, and that as specific restitution was impossible, the plaintiff must fail in his suit, citing Daniel v. Ram Chenuk. Lunatic. A lunatic is, in general, liable for a tort. If a lunatic hurt a man, he shall be liable, but a lunatic, like an infant, is not liable for fraud or malice, unless the court be of opinion that he was capable of conceiving such intention. An action of trespass may be brought against a lunatic, notwithstanding he is incapable of design. For wherever one person receives an injury through the voluntary act of another, this is a trespass, although there were no design to injure, citing Bacon. The rule, as thus stated, has been handed down by successive writers of the common law without such inquiry as to its soundness. It seems to be drawn from some obiter dicta in the shooting case. Weaver v. Ward. Quote, or if a lunatic kill a man or the like, this shall be no felony, because felony must be done animo felonicio. Yet in trespass, which tends only to give damages according to hurt or loss, it is not so, and therefore no man shall be excused of a trespass except it may be judged utterly without his fault. End quote. Pigot says, quote, it is somewhat curious that both this dictum and the rule given by Bacon confuse the intention to injure with the intention to act, and in stating the reason why the lunatic is liable, give a very good reason why he should not be. The general principle, quote, that wherever one person receives an injury from the voluntary act of another, that is a trespass, although there were no design to injure, end quote, is true, but it is strictly limited to voluntary acts. A person, quote, wholly incapable of design, end quote, is not only incapable of intending injurious consequences of acts, but also of intending the acts themselves. It is not necessary to enter into a physiological disquisition of a lunatic state of mind. It is sufficient to say that there is a form of insanity where the deprivation of the understanding is total, fixed, and permanent, where the power of willing or intending is entirely absent. In such a case, it is impossible to call the acts voluntary. Where the insanity is partially, it may be possible that the rule cannot apply to acts of lunatics generally, but only to those who can really be said to intend them, end quote. In the American courts, it has been held that lunatics are liable for torts in general, but not for those torts where intention is a necessary element of the tort, for example, defamation or malicious prosecution. And it has been stated that where vindictive damages might be given against a sane person, the measure of damages against a lunatic would be merely the injury suffered by the plaintiff, citing Addison. The same principles would apply to the acts of a person in an epileptic fit. In an action brought against an innkeeper on the custom of the realm for loss of a guest's goods, the plea was that he was of non-sane memory, and it was held bad, quote, for the defendant, if he will keep an inn, ought at his peril to keep safety his guest's goods, and it lieth not in him to disable himself by plea of non-sane memory, no more than in debt upon an obligation, end quote, citing Cross v. Andrews. The act was one of omission for negligence, and as we have seen, involuntariness is no defense in such a case. And if we are right in assuming lunacy to be a good defense for acts of commission, it is not on account of the lunacy, but because the act is involuntary. Moreover, in this case, the insane man's business was presumably being carried on by his servants, for whose acts he would responsible, sane or non-sane, citing Pigot. Drunkard. As to drunkards, the case is not quite the same. The acts of a drunkard are the most part involuntary. For example, if in reeling about the street he breaks a shop window, But drunkenness as a rule being voluntarily assumed, it is no excuse for the commission of a crime. It will hardly therefore excuse a tort. The act, although at the time of the commission involuntary, becomes by reflection voluntary on account of the voluntary assumption of the state of mind which caused its commission. Or the making of beast of oneself may be likened to the keeping of a beast, and as in some cases the scienter is presumed, so it will be presumed that a man knows that if he gets drunk, he will be likely to commit acts which will produce injuries to the other people, citing Peugeot. 5. A corporation is not liable, and its directors, servants, or other persons who authorize or commit a tort can alone be sued, unless the thing done or omitted is within the purpose for which the corporation exists, citing Edwards v. M.R. Co. Difficulties due to considerations of procedure rather than to obstacles arising from a corporation's artificial personality were felt in admitting that a corporation could be sued. An action for trover lay against the corporation, citing Yerborough v. Bank of England, and so also an action for trover, citing Mond v. Monmouthshire Canal Co. Now it has been established that a corporation is liable for torts committed by its servants and agents, provided 1. The thing done is within the purpose of the corporation, and 2. Done so that it would be actionable if done by an individual. Corporations are liable to be sued for torts of all kinds committed by their agents, to the same extent to which an individual is liable for the torts of his agent, provided that the act or class of acts, in the course of the doing of which the torts are committed, are within the scope of the corporate powers. To fix a corporation with liability for the acts of its agents, 2 conditions must be fulfilled. First, the act must have been within the scope of the agent's employment, and 2. Second, that the employment must have been within the scope of the corporate powers. To the general rule that corporations may be liable to be sued for torts of all kinds, there is possibly one exception. It may be that corporations cannot be held responsible for a fraudulent misrepresentation as to credit of a third person, owing to the difficulty of complying with the terms of Lord Tenterden's Act, which requires that the misrepresentation should be in writing, personally signed by the party to be charged, citing Clerk. Where bodies of persons, incorporated or not, are in charge of works of a private nature, they are in their corporate or quasi-corporate capacity responsible for their work no less than if they were private owners, and this whether they derive any profit from the undertaking or not, citing Mercy Docks Trustees v. Gibbs. Where a public duty is imposed by statute on a corporation, it by no means follows that a private injury caused by an individual by nonfeasance or non-performance of the duty will give him a right of action against the corporation, for example, to repair roads. If the statute shows an intention to impose such liability on the corporation, they will be held liable. They may be liable to a prosecution or to a mandamus, but not to an action for damages, citing Municipality of Picton v. Geldert. The employment of policemen by a railway company to protect their property is an act within the scope of the incorporation of the company, and that consequently the company were responsible for a malicious prosecution carried out by one of such policemen, citing Edwards v. M.R. Co. 6. Married women. Married women at common law were not liable upon contracts on the rule that the contract could not be indirectly enforced by framing the pleadings in tort. In any real cases of tort, a married woman is as liable as anybody else, but inasmuch as in the eyes of the law she had no property of her own with which she could pay damages. Her husband had to be sued jointly with her. Her torts were torts of her husband, and it was said that a married woman could not commit torts, but can merely create a liability against her husband. But under the Married Women's Property Act 1882, a married woman is now as liable to be sued alone for her torts as if she were a femme sole. This enactment, however, does not affect the common law liability of a husband for his wife's torts, and consequently a plaintiff can elect whether he would sue the wife alone or join her husband as co-defendant with her, citing Soroka v. Gattenberg. A married woman may be sued alone, 1. In respect of her antenuptial torts, and sums recovered against her are to be paid out of her separate property, but her husband is also liable to the extent of the property which he received with her, and he may be sued either jointly with her or alone. 2. In respect of her postnuptial torts, and sums recovered against her are to be paid out of her separate estate, but her husband is also liable and may or may not be joined with her as defendant. For torts committed against a wife during marriage, she sues just as a femme sole, and the sum she recovers form part of her separate estate. After the death of the wife or the dissolution of the marriage, the husband is discharged from all responsibility for her tortious acts, unless he himself participated therein, or authorized or instigated them. After the death of the husband, the wife may be sued alone for all tortious acts in which she has participated, whether she was a sole actor in them, or whether they were committed by her at the instigation or under the influence of her husband. And the same rule of law prevails where the husband has abjured the realm or has been transported and is thereby civilator mortuus, citing Addison. In India, the liability of married women is governed by the Married Women's Property Act, 1874.